Welcome, everybody, to the Best Florida Family Law Podcast, brought to you by Jacobs Law Firm. I'm attorney Jonathan Jacobs. I'm so glad to be here today to tell you a little bit about Florida family law. Today's topic of conversation is a motion for temporary relief. What is it? What does it achieve? And what types of motions are there? Well, first, a motion, and forgive me for my last recording, it may have sounded robotic. I recorded it on the way home from daycare in the car, and I did not have any audio equipment to help bolster the sound quality other than my iPhone and a recording feature. Lesson learned, I hope not to do that again at any point in time. A motion asks the court to do something. A motion says, I want the court to allow me to choose my kid's school. A motion says to the court, I want the other side to pay their child support and they are delinquent. A motion says, I want the court to allow me to have time sharing with my children because the other party is not allowing me to. A motion says to the court, I want attorney fees. I want temporary alimony. I want relief. What is relief in a legal sense? It's not like a relief factor or you're curing an itch or an antifungal or neosporin or a cough drop. Relief means you have a serious problem. Through time sharing or finances or the failure of the other party to do something important that impacts your finances or your children, you are asking the judge to order the other party to do something, to take some kind of an action. And if you do not file that motion, it is unlikely the judge will know about the issue. And if you do not call it for a hearing and go before the court, it is unlikely that the judge will hear your evidence, will accept your evidentiary proof into the court file for consideration. A motion for temporary relief can be any number of different kinds of motions, but the goal, the ultimate endpoint, is very likely the same. You want the court to order something to happen that you believe is essential enough to hold a court hearing for. For example, baby daddy, forgive that term, it's as colloquial and commonplace as ever, and it may be appropriate, but this is the term we will use. Baby daddy number one has an issue with baby mama number one. Could be number 2, 3, 4, 5. There are so many different configurations. But baby daddy number one keeps asking over and over and over again for baby mama to allow him time sharing with their daughter. Let's say that their daughter is 10 years old. But historically, baby mama has said, no, I'm sorry, I'm not allowing you time sharing. I do not think you are responsible, or I do not like where you live, or I do not like your work schedule, whatever the reason may be. Call it a real reason, call it an excuse, depends on the case. This may be a real circumstance. And baby daddy may have tolerated this for years. And in doing so, missed out on a lot of time with that minor child. And at some point, baby daddy decided to file a paternity action in family law court, asking for a parenting plan to be established so that he can have time with his daughter, guaranteed by the court, and in writing, per a parenting plan contract, that he can show to law enforcement if necessary, a school if necessary, a daycare center if necessary. In any event, that documentation will be of vital importance to baby daddy number one. Suppose baby daddy number one has already filed a petition to establish paternity, and then baby mama responds with an answer saying, no, I want majority time sharing. No, I want to have child support. No, I want to have school designation authority. No, I want to have what we call shared parental responsibility with decision-making authority. More on that in a separate podcast. And still nothing happens. Because in a lot of cases, the mere filing of a petition doesn't just convince the other side to play by the rules and presumptively offer 50-50 time sharing. Florida statutory law changed last year to really incorporate paternity cases in a similar vein as they would divorce or dissolution of marriage cases, with a presumption that equal time sharing is in the best interest of any given minor child. Suppose that the mere filing of that petition did not convince the other side, or even your attorney asking them politely and officially for a time-sharing arrangement, temporarily or otherwise, did not convince the other side to play ball. This person, baby daddy number one, can file a motion for temporary relief. And that motion for temporary relief asks the court to determine time-sharing, again, on a temporary, hence temporary relief basis, until the parties come up with a full marital settlement agreement or parenting plan if it's paternity, or until they go to trial and the judge decides what is in the best interest of that minor child based on the facts presented and Florida law, the matching and the marriage of the two, if you will. Based upon that motion, baby daddy number one may establish every other weekend, every other week, perhaps even a better result depending on the circumstances. This is the value of it. A motion for temporary relief can give you relief, an outcome of sorts, even if only on a temporary basis, because that temporary basis may be 1 month or 2 years. You do not know how long your family law case will last for. This has been the Best Florida Family Law Podcast with attorney Jonathan Jacobs. I hope that I educated you a little bit today about Florida family law and what a motion for temporary relief is. Please remember, this is not legal advice. We are not your attorney unless you have an agreement with us. And please also remember, this is strictly for entertainment value, for referential purposes, and we hope you do your own research. And if you need legal assistance and you're in the Central Florida area, please give us a call. Thank you so much for joining us today. See you next time.